Stephanie Cannon on behalf of Mr. Young in case is ending in 1381-5188.
All right. And Young, can you state your name, please?
Antonio Young.
All right. And what are we doing?
Your Honor, an offer has been presented to me, and I have given that information to my client. He's asking for a brief adjournment so he can consider that offer.
And Your Honor, if I can also put on the record, the offer was extended back in November. So at the next date, if he does not accept the offer, it will be closed and offer date.
Understood, Your Honor. That's what I said too.
All right. And what are we doing on yours, Ms. Constantine?
Your Honor, there's been a global offer that was extended.
Okay.
My matter will likely be resolved via that global offer, but it is pending resolution of Ms. Cannon's matter. So we would be asking to adjourn to tag along with her matter.
All right. Be able to get an answer by the 29th, or you want the 5th?
Absolutely, Your Honor. I mean, I understand that for Sister
I'll go to
the 5th is better, so we will.
Oh, so you're doing something for somebody else?
I
Really,
am
Cannon?
a team player.
Yeah, okay. February 5th, 2026, 9 a.m. Bond will continue in all of these matters.
Thank you. Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Cannon tried to be a nice person. Court calls the case, People versus Sabrina Wade.
Prosecuting attorney on behalf of the people. Assistant Public Defender Jay Valen on behalf of Ms. Wade. Ms. Wade, can you please state your name for the record?
Yes, Sabrina Wade.
Thank you.
Your Honor, we're just looking to set this for a preliminary examination. Discovery is complete to the best of my knowledge.
People have their witnesses available on the 20th? Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Freshour.
Okay, that's gonna be here, okay? Okay,
Bond will continue. All right.
20th at 9 a.m.
Thank you, Ms. Wade.
Okay,
Okay.
January 20th, 9 a.m. Thank you, Your Honor.
Thank you. Court calls the case, People versus Benjamin Whitfield.
Assistant Public Defender Jay Ballinger on behalf of Mr. Whitfield is approaching. Mr. Whitfield, can you state your name for the record, please?
Benjamin Whitfield.
Thank you.
Your Honor, just seeking an adjournment for the time being. Some discovery to still go over.
This, you got additional discovery. All right. Probable cause conference, February 5th, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
Court calls the case of the People versus really Roger Wharton.
And on behalf
And Stephanie Cannon on behalf of Mr. Wharton, who is approaching. Can you please state your name for the record?
Roger Wharton. Thank you.
Your Honor, we are asking that this be set for a preliminary exam.
So you want a preliminary exam?
Yes.
Discovery is complete.
Your Honor, there is a video, but we have been assured we're going to get it this week. So if they're aware of it, they said it's being sent over. So we are
Okay.
ready to move
But your
forward.
client understands that if for whatever reason that's not there, you're not going to get an adjournment.
He understands, Your Honor.
and
Good.
Your Honor, we do have the video. It's just being sent by our office.
Got it. People have their witnesses available the 20th.
We'll do our best.
Preliminary examination in person, January 20th, 2026, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you so much, Your Honor.
Court calls the case of the People versus Tierra Williams.
Good afternoon, Assistant Public Defender Dottie Leib on behalf of Ms. Williams. Ms. Williams, can you please tell the court your name, ma'am?
Yeah, well,
Thank you.
And Your Honor, I do have a green sheet requesting an adjournment. And we do have a deal worked out. We're just waiting to get a restitution number from the people, which he's indicated we should be able to provide shortly.
January 29th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Case People versus Gabriel Wilson.
Alex Chaplowski for people.
Brian Bowling on behalf of Ms. Wilson, Your Honor.
Your name?
Gabrielle.
Judge, I'm asking for an adjournment so we can have some ongoing or additional plea discussions regarding this matter.
Matter will, probable cause will be adjourned February 5th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Let's call the case of the People versus JaVale.
Assistant Public Defender Chelsea Vergil is with them on behalf of JaVale Wilson. Please state your
Take
name.
your hands on your.
JaVale Wilson.
All right.
Let me briefly approach.
You may. All right, record should reflect we've had a bench conference in this case. Understanding what needs to go on or at least be looked at. I'll adjourn this to February 5th, 2026, 9 a.m. Okay,
Thank you, Your Honor.
bond will continue. Thank you. Court calls the case of the People versus Asil Al-Sahori.
Good afternoon. Jamil Kuja appearing on behalf of Asil Al-Samhouri, who's present on Zoom.
All right. Ma'am, can you state your name?
Asil Al-Samhouri.
Thank you. I have a plea form before me that indicates she's going to be pleading to an added count 2 of larceny by false pretenses, 200 to 1,000, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. There is also the prosecutor and defense agree to a sentence agreement of HIDA. I'm also checking the sentencing judge waiver. She does understand I would not be the sentencing judge. Counsel.
Yes, Mr. Al-Samhouri, you understand that Judge Simpson would not be your sentencing judge. It would be transferred to another judge.
Yes.
Okay, all right.
Thank you, Your Honor.
So that's the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct. All right. Mr. Kuja, is that correct, sir, from your understanding?
It is correct, Your Honor.
All right, very good. Ma'am, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
State your name again for the record, please.
Asil Al-Samhouri.
All right. Ma'am, it is this court's understanding that you are going to be pleading to the misdemeanor charge of larceny by false pretenses, 200 to 1,000. That
Yes.
is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, I do.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, Judge.
All right. You understand that you're waiving or giving up all of the rights contained on that form, including the rights contained in paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Judge.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Judge.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
December 22nd, 2023, at the location of 1166 Ecorse Road, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty? Well, let me ask this. Did you present a check somewhere?
Yes.
Okay. And you knew at the time of presentation of that check that there was something defective in that check where you shouldn't have been receiving the proceeds?
Yes.
Okay. And did you receive any proceeds?
Yes.
All right. And the amount that you received, was that in excess of $200?
Yes.
All right. And just so that we're clear, that was $200 that you were not entitled to, correct?
Correct.
Legally or otherwise, correct?
Yes.
All right. Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined under the Michigan court rule between the time of my acceptance of your plea and the time of sentencing, that number one, you could not withdraw your plea. And secondly, the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I do.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor, thank you.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be February 10th, 2026, 10 a.m. before Judge Washington. Bond will continue. All right. Thank
Your
you.
Honor.
Thank you, Your
Have a
Honor.
good day, bro.
Yes, sir. Good seeing you, Mr. Kuchar. Court calls
Thank you,
case. People versus Miko Stewart.
Good afternoon, Your Honor, bringing the cook for the people. Good afternoon, Your Honor, Yvonne Paramount Keller, P 84328 appearing. Mr. Stewart, who was present to my right. State your full name. Stewart.
Thank you. And you're requesting an adjournment?
Yes, Your Honor. I've had the opportunity to make productive steps with the prosecution towards resolution. We just need a little bit more time to run into the goal line, so to speak, Judge.
Okay. Probable cause conference, February 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Court calls case People versus Kevin Jackson. Kevin Jackson.
Andrew Childers appearing on behalf of the people. Here. Mr. Jackson is all the way.
Good afternoon, Your Honor. J. Grant Miller, P 58658 on behalf of Mr. Jackson. Please state your name.
Kevin Jackson. Okay, what are we doing?
Your Honor, I have the discovery except for the body cams. We'd like to set it for an exam because the report
If you don't
indicates.
get the body cams before I set it for exam, that's not going to be the basis for an adjournment.
I understand that. The police report clearly says they didn't recover a weapon on the body cams. So I'm not sure that I need them.
Okay, I don't need to know all that. You want it set for exam?
Yes, please.
People have their witnesses available the 20th.
That's fine.
Preliminary examination in person. January 20th, 2026, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you. Bond continue. Court calls case People versus George Capone.
Rob Down, Assistant Prosecuting Attorney on behalf of the people.
Mr. Pan's in the hallway. Could you ask George to come in, please? J. Grant Miller, P 58658 on behalf of Mr. Pan, who will be approaching momentarily.
Want the letter. You sealed that. Your name?
George.
Your Honor, I've been in touch with the prosecution. I believe we have all the discovery and everything else, and we just need to set a date.
People have the witnesses available the 20th.
Right.
Preliminary examination in person, January 20th, 2026. 9 a.m. That is before Judge Moore.
Thank you, Your Honor.
On continue.
Thank you, Your Honor.
Thank you. Calls case People versus Daryl Jarrell.
People.
Kyle on behalf of Mr. Jarrell. Daryl.
How you doing, sir?
And
Waiving.
yes, Your Honor, the court should be in possession of a executed waiver form.
Sir, you're waiving your right to a preliminary examination in these matters? All right, you understand that that's a hearing where the people would have to show by probable cause that the offense alleged or the offenses alleged were committed and that you committed.
I do.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2.
Stand mute, waive formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
February 26th at 1:30 before Judge Slide.
February 26, 2026. 1:30 before Judge Slay. Bond will continue. Thank you.
Thank you, Judge.
So, yeah, make time, but
I'm just.
do you have them?
Not yet.
Okay. Court does call the case, People versus Malcolm Hanks.
Noon, Judge Christopher Quinn appearing on behalf of Mr. Hanks.
Mr. Hanks? Oh, okay. Well,
Andrew Childers appearing on behalf of the people.
your name, sir?
Malcolm Hanks.
Thank you. All right, what are we doing?
Need another day, Judge. There's some, I think some video discovery that I need to obtain that I haven't received.
Video discovery. January 29th.
Can I get the 5th, Judge? I know, I have a trial that week. The 5th would work better.
I'll give it to you, but you guys got to be ready to go when I say you need to be ready. February 5th, 2026.
Thank you, Judge.
9 a.m. Bond continue. Thank you, sir.
That's what I have to be. February 20th.
February 5th. Yes, sir.
Okay.
All right. Court calls the case of the People versus Tracy Reed.
Good afternoon, Your Honor, Raymond Cook, the people.
Christopher Quinn appearing on behalf of Ms. Reed.
Ms. Reed, you need to unmute, state your name, and get someplace stable. Seriously. State your name.
I can tell you what we need to do, Judge.
I cannot. I can't hear you, ma'am.
I can confirm for the court that that's Tracy Reed, Judge.
Okay, fine. If she's gonna appear via Zoom, she needs to know how to work it. What are we doing?
I would like to set it for a PCC on the 5th as well, video discovery, Judge.
Probable cause conference. February 5th, 2026, 9 a.m. Because she doesn't know how to work Zoom, that proceeding will be in person. Bond continued.
Thank you, Judge. Have a good day.
This moment looks minor, but it matters. Courts tolerate technology until it disrupts order. When a defendant can't appear properly, judges read that as disrespect or risk. And once that perception forms, everything else gets harder.
Okay, so the people versus Nora Rita.
And good afternoon, Your Honor, Jessica Holland, P 86695 on behalf of Ms. Rita, who stands to my right. Please state your name for the court. Nora Rita.
Good, I could hear that. Go ahead. All right, what are we doing? You're seeking an adjournment?
Yes, Your Honor, we're asking for the 29th.
You're asking for what day?
The 29th, Your Honor.
She's so nice. I really should chew her out for asking for a day, because I was gonna set it for whatever I want. Press conference, January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Happy New Year, Judge.
And to you.
Thank you.
Court calls the case, people versus Joseph Salazar. You're muted, Mr. Nelson. Still muted. You're saying brilliant things. I just can't make them out.
There's the brilliant things, Your Honor.
There we go. Now we're going to hear the brilliance come through.
Okay.
State your appearance, sir.
Your Honor, Mitchell Nelson, P 22825, appearing on behalf of Joseph Salazar, who's also appearing via Zoom from Miami, Florida. Introduce yourself to the court, Mr. Salazar.
Joseph Salazar.
And Your Honor, we are asking for additional.
Was the
time.
Miami, Florida thing just like white? It's like 30 degrees here. Did you do that just to like upset me or what?
I wish I was there too.
Okay. All right. What are we doing?
For a continuance, we're near a resolution that would not require Mr. Salazar to return to the state of Michigan, and I think about a month would be adequate.
I'm going to make him return just so that he probably doesn't know what cold feels like anymore. So
the case is very old, so it's been a long time.
Okay. All right. What I will do, probable cause, well, February 5th, will that give you enough time?
Yes, thank you, Your Honor.
If you think.
Judges often use humor like this as a pressure valve, but don't mistake it for softness. The message underneath is authority. Even when the room laughs, the court is still keeping score.
All right, February 5th, 2026 at 9 a.m. or as your invite indicates.
And thank you, Your Honor, for the courtesy for allowing me to do this via Zoom due to the family emergency.
Not a problem, sir. All right. People who have practiced in the manner that you practice are always entitled to that courtesy as far as this court's concerned. All right. Thank you, sir. Have a good one.
Happy New Year.
And to you. Salazar, stay warm. Court calls case. Court calls a case of people versus Nicholas Smith.
Good afternoon, Your Honor. Robin Kennedy. Nicholas Smith, who's present via Zoom. Mr. Smith, can you please state your name for the record?
Yes, Nicholas Smith.
Okay, there you are. Okay. And what are we doing on this today?
Your Honor, I do believe we have a resolution. The last time that we were here, we adjourned just to ensure that the documents made it to the court file to complete the plea.
Yeah. Were they sent in?
I had provided them to the prosecutor prior to the last hearing. I believe we were just waiting on their signatures.
Oh. 'Cause I don't have any paperwork.
I'm not sure generally, Your Honor, I the complete form, sent it to the defense counsel and have them forwarded along.
To the court.
I don't have any details emails from Miss Kennedy about that. Not that, based on the notes on the file, I don't believe she's making any sort of misrepresentation, that there is an agreement and that Mr. Smith has been admitted to an Ingham County district, I'm sorry, the Ingham County sobriety court. That's all well and good, but we do need to take this form, so.
We don't have the forms all complete. All right, here's what, he's already been accepted and I don't really want to delay, but
Do it quickly.
well, it's been a long day. If I put it out 1 week, I usually don't like adjourning 1 week, but can we do it on the 15th and get everything in and then make sure it all happens?
I will be out of the country on the 15th, Your Honor, but in order to get it complete, I would have no problem having someone stand in for me, just so that we can get the complete. I will make someone available and have them submit all of the Zoom documentation in my place.
She's going someplace warm. After that Miami
I am.
comment, everybody appearing here is going someplace warm. I'm getting a little irritated. Bird, are you going someplace warm?
None of the time, so.
Okay, all right, because if you were, I'm coming off the bench at you. All right, here's what I'll do. Let's get that in there and I'll adjourn this out to January 15th, 2026, 9 a.m. or as your invite indicates, bond will continue. All right, and we'll
Thank
get
you,
the
Your
paperwork into
Honor.
me. We'll take care of it. Thank you.
Excellent. Thank you so
All
much.
right. Yep. Be safe on your journey, please.
Thank you, Your Honor. Have a great day.
Court calls the case, the People versus James Young.
Thank you for the people, Your Honor. Good afternoon, Your Honor. Barton Morris, appearing on behalf and hopefully with Mr. Young. Yeah, he's there right there. We had just received some discovery this week. I have not had the opportunity to review it, and it might be voluminous, and I'm asking for likely a final probable cause conference.
All right, Mr. Young, can you state your name, please?
James Young.
All right.
And for the record, Your Honor, that is all correct. That should be the last piece of discovery in this matter. If Mr. Morris wants to come and view any of the images that are discussed in said discovery, we'll have to schedule an appointment with U of M Police Department to do so.
Okay, so there may have to be. Let me do this. I'll adjourn then probable cause February 5th. Will that work for you, counsel?
Checking. Yes, Your Honor.
All right, February 5th, 2026, 9 a.m. or as your invite indicates. Bond will continue.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Court calls the case, People versus Haley Garcia.
And good afternoon, Your Honor. Attorney Maxwell Dubin, P number 86012 on behalf of Ms. Garcia, who appears via Zoom with consent, Your Honor.
Your name, ma'am?
Haley Garcia.
All right. What are we doing today?
Your Honor, I've been with the prosecution. We are close to a resolution. I'm just going to ask for another brief adjournment on this one due to the fact there is immigration issues at hand. However, I do and I'm confident.
Okay, but I don't want to hear about that.
Okay.
I really don't want to hear about that, but you need more. You need more time.
Correct.
February 5th, 2025, 9 a.m. bond continued.
Thank you so much, Your Honor. I hope you and your staff have a
Which
wonderful rest of your
prosecutor are
day.
you dealing with?
Myself.
So
You are?
yes.
Then you can explain to counsel some things that I may not want to hear, and that if I hear them again, we are going to have a real problem.
Understood, Your Honor.
Thank you.
Understood, Your Honor.
Court calls the case, People versus Denicia Charles, I think.
Yes, Your Honor. We please the Honorable Court, Brandon Bird on behalf of Denicia Charles. Ms. Charles, can you please state your full name for the record?
Denicia Janelle Charles. Thank you.
What are we doing?
We're setting this matter for exam on the RNO, and I believe the child abuse will be dismissed, Your Honor.
That is correct, Your Honor. It did inform me. We'll be dismissing count one.
Count one. Then discovery is complete then as to that charge.
As far as I know, Your Honor.
And would the people have their witnesses available the 20th? Okay. Preliminary examination will be set January 20th, 2026, 9 a.m. before Judge Fresh Hour. And that's only on count two. Got it. All right, Bond will continue. Thank you.
Thank you.
Court calls the case, people versus, is it Darius Johnson?
Yes, Your Honor. Brandon Bird on behalf of Darius Johnson for case, the case ending in 5312.
In the case ending in what? Oh, 5312. Gotcha.
Excuse me, Brian Bowling on behalf of Mr. Johnson in case ending in 1724, Judge.
Here you go. All right. What are we doing? You're requesting an adjournment?
Yes, please, Judge, for additional plea discussions. Both, but
Probable cause conference, I will adjourn to February 5th, 2026, 9 a.m. In both matters, bond will continue.
That was January 20.
No, I gave you February 5th.
February
You want the 29th? I mean, I can give that to you.
Oh, February 5th is all right.
Well, you're trying to cause me a problem, aren't you?
Sometimes my ears, you know.
All right, thank you. Bond will continue.
Can we address one issue of bond, Judge? Real quick.
Sure.
Hoping to travel to Texas. The
Why?
Dallas area for a family matter, from January 10th through the 18th.
January 10th through the 18th in Texas.
Correct.
What part?
Dallas.
Dallas? That's where them Cowboys are.
Yeah, but they're not playing football anymore.
I know, and I don't like
He doesn't either, Your Honor.
You don't?
Lions fan.
You're a Lions fan? Okay, that'll work. Maybe I'll let him go. Oh, you fill out a form for me. All right, he can go to Texas. Those include your travel days, the 10th through the 18th? Yeah. All right, you can go to Texas, 10th through the 18th. Sure, all right. Thank you. I've already put him there. Off my back. Court calls case, people of the state of Michigan versus Kevin Jones.
And on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Kevin Jones. Mr. Jones, can you please state your full name for the record?
Kevin Jones.
I'd like to set this matter for exam, Your Honor.
For exam?
Please.
All right, your discovery is complete.
As far as I know, Your Honor.
People have their witnesses available the 20th.
We'll do our best, Joe.
Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you, sir.
All right.
Court calls the case, the people versus Anastasia Ricks.
Andrew Tool is appearing on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Anastasia Rakes. Ms. Rakes, can you please state your full name for the record?
Anastasia Rakes.
All right, first of all, Your Honor, we tried to take a plea last time and it didn't go over so well, but I did get a chance to go over the video with my client, go over the plea, and I believe she's ready to plea now. Now, I believe we have another matter that we have to discuss about the bond violation in which my client has a warrant. And whenever you want me.
She does. Let's deal with the bond violation. I may not be taking a plea today.
Gotcha. Okay, first of all, Your Honor, my client indicates to us that she wasn't drinking.
She what?
She wasn't drinking. And honestly, I don't say this about everybody, but I do believe my client at this point. First of all, the blood alcohol level was 0.04. It was 0.04. If my client would have been drinking, especially with the problem that she has, it would have been way over 0.04. It was only for that one day. If you notice that she went.
If she had been drinking, it would have been over that amount?
It would have been over that amount because my client doesn't know how to stop drinking. And she understands that she has a problem. That's just one thing. But if you notice that she went through Christmas, she went through New Year's, and I believe Thanksgiving, you had zeros all the way across the board. And if you remember this case, my client's the one that actually said, I don't want the breathalyzer because the breathalyzer is too easy to cheat, and put herself on this alcohol tether to show the court that she couldn't that she wouldn't drink. She indicates to me that she is a clean. She's obsessed with cleaning, and it is possible that those chemicals got to her tether. But in all honesty, Your Honor, dealing with the facts of the situation that we got in front of us, we got somebody that asked to be on a stricter, to be on something stricter, to show the courts that she wasn't drink, to address her problem, even more, to make sure that she's not cheating the court. We got somebody that's dealt with alcoholism for a long time in life. And like I said, when she does drink, she drinks a lot. And she understands that. And she's looking for help. She's searching for help. She showed the court that she's searching for help. So when she does drink, she drinks a lot. And the fact of the matter is, that's why that 0.04 doesn't, I can understand when she told me that I'm not drinking. I'm not drinking. I wouldn't have put my kid in that situation. I'm all he has at this point. And she's been responsible. She showed her response. She showed she's been responsible. Like you told one of my clients, the most major drinking holiday days that then came with Thanksgiving, the day after Thanksgiving, New Year's Eve. She showed that it's been nothing in her system. So I do believe it was an honest mistake. And I do believe that my client can't just drink one beer. And I honestly believe that. So, Your Honor, we're just asking that you give my client that you give my client a chance. She showed you that she could go without drinking. I believe that violation. When was that violation, Your Honor? November or December 13th?
December 17th.
December 17th.
Into the 18th.
But if you notice the alcohol level was dropping when it went into the 18th. So it went to 0.04 and it went lower. It went lower and lower each time. So it's not like she was continuing drinking.
Which cuts against the fact of thinking that it's a chemical. Because a chemical wouldn't happen.
I'm not.
It would either remain or it would dissipate faster than the body would be absorbing any alcohol.
And that's why she didn't say she knew it was a chemical. She said that could be a possibility. But one thing she said, I know I wasn't drinking. I know I wasn't drinking. And for the fact of the matter, everything surrounding this situation, I believe she wasn't drinking. Now, even if we were to take that not to be true, what she said to me, I do believe we have a lot of mitigating circumstances to allow my client to stand out of jail. But I'm standing in front of you today that's saying that I really believe my client when she said she wasn't drinking. I've seen the video of when she drinks. I heard the discussion that the witnesses had with the police that talks about when she drinks and how much she drinks that she just can't stop. So a .04, I can't see my client taking a sip of anything and stopping. I can't.
Response from the people.
I would think up to, distraction, these sorts of things as I always do. Like .04 to me is not nothing.
Right. How long has she been on the tether?
For about 2 months, maybe 2 months.
Pardon?
Yes, I've been on it like a month, 2 months.
And as I stated earlier, Yana, she's the one that was taking the breathalyzer and came in here and asked to be on the tether instead of the breathalyzer to ensure that she doesn't think that.
Here's what I'm gonna do. You want this adjourned, Grant?
The bond violation, we were gonna say.
Go ahead, what?
We'd like it dismissed, but if we can adjourn it, Your Honor, then yes, please. We would like it adjourned, but I do know my client is ready to proceed with the plea, but if you're not at that point, then.
I'm not at that point yet. I mean, I'm not saying that I won't, but here's what I'm gonna do. I'm gonna adjourn the probable cause and the bond violation. I'm gonna adjourn it out to February 12th, 2026, 9 a.m. And I'm just gonna say it this way. What I really have right should do is I should put you in today. I'm not gonna do that. Mr. Bird has convinced me not to do it. That is something that is against my normal practice, but I'm not gonna do it. Well, don't thank me yet. Because normally you might spend a week, 10 days, get your help, do whatever. But now we're gonna make a deal. I'm gonna adjourn this out to the 12th of February. We have any event whatsoever, I'm not listening to any of that. I'm not listening that it might be a chemical. I'm not listening that something went wrong. I'm not listening to anything. You're just gonna go in and you're gonna do 60 days. Understood?
Yes.
So we'll put it up to that date. Bond continue.
Thank you, Your Honor.
Yes, the warrant's going, so reinstate the previous one. Court does call the case of the people of the state of Michigan versus the Chardonnay. Sanders.
Yes, Your Honor. Brandon Bird on behalf of Chardonnay Sanders. We have Ms. Sanders on Zoom.
Do we? Nope, just me.
And respectfully, I did talk to her earlier. I did talk to her earlier, and she indicated that she wasn't going to be able to drive or find a ride here, and asked could it potentially get on Zoom, but at that point it was too late for me to ask, Your Honor. Respectfully, I'm asking you to adjourn. If she has shown up to the rest of it, respectfully, I'm just asking to give Ms. Sanders a second chance.
Bench warrant will issue for defendant failure to appear. Bond 10,000, cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Khalil Taylor Jefferson.
Good morning, Your Honor. Brandon Bird on behalf of Khalil Taylor Jefferson. Mr. Jefferson, can you please state your full name for the record? Khalil Taylor Jefferson.
You're looking for an adjournment of this?
Correct, Your Honor.
February 5th, 2026, 9 a.m. Bond will continue.
Thank you.
Thank you. Court calls case of the people versus Aaron Wallace.
Good afternoon, Your Honor. Philip Wypert on behalf of Mr. Aaron Wallace.
Your name?
Aaron Wallace.
All right. Requesting an adjournment.
Yes, please, Your Honor.
Record was 29th or the 5th?
Fifth would work better for me.
Why is that?
I got a serious conflict on that day.
What? Are you?
My wife.
January 29th. No.
I appreciate it, Your Honor.
February 5th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Your Honor. Thanks.
Court calls the case, People versus Amina Giko.
Good afternoon, Your Honor. Raymond Cook to the people.
Who?
Mr. Was here a few times today, but not currently.
Well, ma'am, hello, what's your name?
Amina Diko.
All right. We have misplaced your attorney. I'll say it that way because he's been here all day and I don't,
That's fine.
he might be downtown before the felony court. So what I'll do, or circuit court, what I'm gonna do is I'm gonna adjourn this out for you, okay?
Okay, I understand.
And what day did we do that we did other things?
I don't know.
There was a day. Here's what I'll do. No, I think he did not like the 29th. Who knows? Depends on when you were calling. So, ma'am, here's what I'll do. Ma'am, I'm going to adjourn your case out to February 5th.
Okay.
2026 at 9. Get in touch with Mr. Kilowald. We'll try to get in touch with him also. Tell him we set it that date. It may be that, I remember talking about his schedule. It may be that the week before is a better week, but I'll set it for the 5th. Do it that way, okay?
Okay, thank you.
You're welcome, Bond. We'll continue. In custody motions, how many do I have? Don't.
You have 3. Okay. I have nobody to bring up for you.
He's refusing. But whose motion?
Mr. Butler.
Is Ballinger around?
Yes. Yes.
Yeah.
He went in the little office next to me.
Court does call the case, Other People of State of Michigan versus Ronald Fleming.
Good afternoon, Your Honor. Ashley Lottie Feldes for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Fleming, who is not present in person today for the record.
Yes.
And the people submitted a motion, Your Honor, all that, Ms. Lundy.
That's correct, Your Honor. The sum and substance of our motion the court has reviewed is basically to ask the court to have an iPad brought to the defendant's cell. He's refused on a number of occasions, both before and after being found competent to come and participate in these proceedings. I know the court is very familiar that the people are entitled to a speedy resolution of the case, just as the defendant is. We are asking that the court have the iPad brought into his cell at his next PCC, advise him of his right to be present, and if he should continue to refuse to come up, to make the finding that he is voluntarily refusing and allow us to get this set for a preliminary examination and go ahead and continue on. I think defense counsel has a couple of other concerns. I'll let them place on the record, but essentially we just want to get the case moving, Your Honor.
Understood.
Your Honor, I would echo much of what Ms. Lundy said. I obviously want an opportunity to speak with my client as well. He's been refusing to see us for months now. In terms of what I am looking for is, I imagine that the court is going to compel him to come through at least what Ms. Speltz has suggested through an iPad through the cell, and that's all fine and well. I just think at this point, I don't know what he looks like. I haven't talked to, I know what he looks like. I just don't know how he appears at this point in terms of where he's at with competency. So I think this would give us a good opportunity to at least to see him, be able to evaluate him either on the record or explain to him, the consequences of not participating in preparation for his examination. It would give me an opportunity to tell him as well that we do have a social worker in our office, and I'd like an opportunity for her to start working with him. I think that that would be an excellent idea in terms of getting him prepared. Otherwise, Your Honor, I would just be asking to compel for PCC in lieu of an exam at this time. I just want, again, to get an understanding of how he appears for purposes of whether I
That's
need.
what I'd be doing. I'd be adjourning this out, compelling him to appear via through the tablet, apprise him of that he needs to participate basically in the proceedings, and that if he doesn't, the proceedings will go forth without him. I will let you know that in the past, when we've had this issue, and it occurred in a different way, but where we had a defendant that voluntarily or may have involuntarily decided he did not want to be present, but voluntarily, but how they did it. Then at the exam, a tablet was placed outside their cell. The exam is conducted. They're there. I try to allow counsel an opportunity to converse with their client where it's going to be necessary, but we just proceed with the exam. So that's how I'd anticipate this proceeding, given his failure to do that.
Certainly.
Thank you, Your Honor. In my review of case law, it's pretty clear that he has to be given the
No.
information, and then it should be refused, then we can move forward without it.
That's right.
So I appreciate the court doing this.
So I'll adjourn the probable cause to the 22nd at 9 or what, it will be in the 9 o'clock block. And then we'll get the first part of this done. I would need, if you would, Ms. Feltes, I'll grant your motion. So if you'd prepare a written order to that effect, so that.
I will, or I will ask a friend for help. Yeah.
Okay.
And then, Your Honor, I would ask the court for future consideration, understanding that this is being set for a PCC first. I would ask the court for future consideration in setting this for an exam for a special date. I would be asking that it be set for some Friday in the future. And that's for purposes of.
You know what judges are available on Friday?
This one?
I'll let you.
Judge Washington?
I will let you ask on the 20th.
Okay, thank you.
Not sure what answer I'll get. Okay.
All right, and that's for purposes, I know Mr. Pesky wants to be involved in this. So.
Ms. Noveski wants to be involved?
She wants to sit second chair.
No, that's not happening. Then I'm gonna make it as. All right.
I'll give her your regard, Your Honor.
Yes. Bond will continue.
Thank you.
Thank you. Yeah. Well, hold on before we call it. On the page story. But who's got
Mr. Bird is on.
Owens? Okay, on the Owens matter, before we even begin to bring them out, as I had indicated, I reviewed the letter. I do not believe that it at all is privileged. And so that you can understand why I start there, is the communication is not directed to counsel. That's the first thing. And there is not a way that one could even say that it's directed to counsel, because in the communication, it is stated that counsel's name is placed on the envelope so that they won't go through it. Okay. So I don't think in any stretch of the imagination it's privileged. What I did say is that before I would make, just your day, Bird. Before I would make a ruling, and I will continue with that, I would present the communication to defense counsel, let you look it over and let you, that being my assessment, if you believe that a different assessment, that the information is privileged, I would allow you to do that. So I have a copy.
Oh, good, because I was gonna let the court know that Detective Pearson was had a lot going on this week, as the clerk can probably remember. And so he.
Yes, if he
not
called
here.
me regarding a search warrant, yes, I know he does.
So he's not here right now, so I'm glad the court has a copy, because I was gonna say, we got to get a lot of evidence, and I have some deputies who can help me with that potentially, but I don't have Pearson.
Yeah, no, I did that after seeing it because I knew that was gonna happen. So, Mr. Bird, before I call them out, I'm gonna give you this copy so that you can look at it.
And I haven't seen it, so.
And I'm not intending on sharing it with the prosecutor. I want you to look at it first and let you give me your arguments, if any, so he can have that. All right. So while we await that, court's gonna stand in brief recess. All right. Well, before we bring them out, we already have the exam set, right?
Well,
That was gonna be talking.
that's part 2, Your Honor.
Nothing to argue here. Nothing to argue here.
With the letter? Yeah, I didn't think so.
It's really unfortunate that he talks about my client.
I'm gonna make no comment on that, and I think what I'm gonna do is I'm gonna take that copy back. The prosecutor.
You want an order, Judge?
Yes, I'm gonna need an order that can be, and then maybe what we should do is bring Mr. Owens out and deal with him first. I can't bring him out at the same time, I know that.
Okay.
All right. You know, wow. He was gonna, I don't know what did. I listened to that. I didn't listen to that. No. You know, no, that's okay. I got you back because his client left this time. I got you. I will, what you do, Owens, first.
They will not have any interest. Oh. They're like, they don't have some money on transporting people back and forth. And now, their skates.
I don't know what that was. You know, that shows how disciplined you are. Because after 197 cases, I would have taken this. I would have taken this. It's 5 o'clock. You were delaying my days in. Court does call the case on the people versus Devante.
Good afternoon, Your Honor. Ashley Lundy, Felton for the people.
And good afternoon, Your Honor. Brandon Bird on behalf of Devante Owens. Mr. Owens, can you please state your full name for the record?
Devante Owens.
And first of all, before we deal with the PCC, there's an issue that we had to deal with regarding a letter that had come through into the jail. It was a letter that contained Mr. Bird, his attorney, as the individual who had sent the letter, but a Roundtree address. I think that was it, an address to the jail.
I think it was the other way around, Your Honor. It was a letter leaving the jail from
Yes.
the defendant.
Correct.
Addressed to the name Attorney Bird with a Roundtree mailing address.
You are correct. And I have, upon an in-camera review of that letter, so that the record is clear, determined that that letter was not privileged. Specifically, I will indicate there was a statement as to why Bird was on the letter, which clearly would dictate that it was not intended for Mr. Bird and therefore not subject to attorney-client privilege at the outset. Mr. Bird reviewed it. I do not believe there was an objection to the court's finding that it is not privileged.
Correct, Your Honor. No objection.
And I also, because of what might be implications.
This is a huge legal moment. Attorney-client privilege is sacred, but only if the communication is actually meant for the lawyer. The second intent breaks, protection disappears. That's why this ruling matters far beyond this one case.
Regarding the co-defendant, I allowed Ms. Barnwell to review that on behalf of her client. While there may be objections to the mentioning of her client, the court believes that there is nothing in there that is privileged per se. There may be other issues regarding the admissibility of some of the statements as against her client, but the court doesn't see any issue with it being presented to the people or any objection that Mr. Sweat could raise. Ms. Barnwell, would you agree with that? She goes, I was listening. I don't know what you're talking about.
No, I will object to any of that coming in any way against my client based on Bruton versus United States.
Right, and that's what I meant in terms of other issues. There may be Bruton issues with it, but as to its presentation to the prosecutor, their use of it, their proper use of it, there is not an objection, I believe, by Mr. or that can be made, quite frankly, by Mr. Sweat, except to the extent that it may be used as against him in violation of Bruton. Right. Okay. All right. So the people may get that letter. I only made one copy. So when the people get the letter, they're going to be required via discovery to give that to counsel.
What'll happen is, I think does the court want an order?
Yes.
I'll prepare an order. Once that's done, I will request the sheriff's department gets it out of evidence and scans it into the file, and it's disclosed in the normal course of discovery.
All right.
And then we're ready to talk about our exam on Tuesday, whenever the court is.
And I am also.
Okay.
I'm ready.
There is a witness who the people intend to produce an exam who is currently in the Michigan Department of Corrections. And on Tuesday, we found out we couldn't get him here in time. I called Mr. Bird yesterday to let him know, and Mr. Childers called Ms. Barnwell yesterday to let her know. Maybe called her on Tuesday. So that person that we need, ultimately, we could start on Tuesday, but the people are seeking an adjournment of the exam to do it all in one go. I will let defense counsel state their positions as to that, and we'll kind of go from there.
All right.
Me personally, I don't have an objection to it, Your Honor. We also just
An objection to the adjournment.
to the adjournment. We also just found out that there's more discovery. I'm not sure how much of discovery is, but that was given to us either yesterday or 2 days ago. That is another thumb drive for us to pick up. For me and Ms. Barnwell to pick up from 22nd Circuit. I did talk to Mr. Childers. I'm not sure if he's still here. He said he was going to give it to me. He said he believed he brought it here and was going to give it to me.
He left.
Yeah, he left. There was, so I will, as to the discovery thing, I did find out from my office earlier this week that there was one flash drive that we had originally had in November that we thought had gone out, but it hadn't. So as soon as our discovery people realized it, let me know right away, and we got it processed as fast as possible. We apologize for that. We tried really hard to be good about discovery, but it looks like this was just one that got missed, and that's what happened.
And I'm not sure how much discovery is on there, Your Honor.
Rena, I saw Mr. Childers in court. Was that yesterday or the day before? I'm getting all mixed up. But I saw him in court on a completely separate matter. And then he told me to go. Yes, that was yesterday. So then I walked to his office and picked up the flash drive. I didn't get an opportunity to look at it.
Okay, you didn't get an opportunity, but you have it.
Right, I do have it. I will object to a continuation of this. It is, let me say this. The witness that they're anticipating is a person who has no knowledge of this case. What did you say his name was? Oh, you can't say it on camera? Okay.
It's Mr. First name is Alton, last name Ford, FOR.
Sorry about that. I got to write it down this summer. Mr. Alton Ford has absolutely no knowledge of this matter, and he was eavesdropping as to Mr. Owens. Mr. Owens was having conversations with people. And on Monday, July 29th, Mr. Ford had no knowledge. You see him talking to a detective. And like he's a professional snitch. And then 7 days later or so, he had knowledge, having listening, eavesdropping on what Mr. Owens was telling somebody else he was confiding in.
And all I can say, allegedly telling you.
And I'll tell you this, Judge. Bruton versus United States applies to my client because there's no reason for us to keep with the attorney. This is a preliminary exam.
Right, but I don't know. I understand what you're telling me. I don't know, at least at this point, whether what would be Mr. Ford's purported statements are as a result of his knowledge or a result of what he heard. I at this point, as I sit here, I don't know.
There's tons of video that thankfully they supplied us with video with Mr. Ford talking to the detective and also with him listening. You see him on camera.
Okay, but what I'm saying is I don't know that, but it still may be, and why the people may want it, it may be evidence that would be as admissible as against Mr. Owens. But certainly the court would be very careful to separate that out as to whether or not would attribute any of those statements as against your client consistent with Bruton. So, well, here's the reality of it. And so that, you know, and I think I'll make short work of this. Mr. Bird, on behalf of Mr. Owens, still has to get the discovery that's there. So that would be one thing that this court would look at it then being adjourned. The other aspect of it is that if the people indicate they need to call that witness, we could start it on Tuesday, but it's just going to be adjourned out. So if you want to do it over a few days, I'm here every day, so it's not going to bother me, but I don't know that council really wants to do it that way.
I did want to have my client in when I'm talking about this adjournment.
Yeah, no, and that's fine. I'll let you make the argument when your client is here. I was trying to ease on the jail to not, because it would have taken a number of different officers had I wanted both out. And we will have to have that at exam, but so anyway. So I will adjourn it. I will grant the adjournment in this case, the preliminary exam. We had set it for the 13th. I have February 3rd. I don't know, would have read to.
That only should be enough time. That's about 5 weeks, 4.5. So that historically has been enough time for the person to read. I think the person's in Jackson, so.
Oh, okay. Yeah.
But we'll certainly shoot for that date, Your Honor, and I'll get the request in tonight.
So I'll adjourn it to February 3rd, 2026. 9 a.m. That's before me.
I do have a 1:30 in front of Judge.
Whoever is on Tuesday, she may.
No, I think it's either Judge Conlon or,
Kunky. Who does Tuesdays?
Hunky.
Kunky.
Yeah.
All right. So that's what I will do regarding the adjournment. The order will be prepared regarding my issue of the letter, and then I think that's it. And bond will continue as denied regarding Mr. Owens. Thank you.
People review the
I'll see you.
that
I'll
the
see
court made a
you
copy of.
this weekend.
Yes.
Okay, we'll do that at the end.
Okay. Oh, there you go. Okay, court does call the case of the people versus Adonis Sweat.
Actually, Monty tells us for the people.
Oh, they
Good
did.
afternoon, Your Honor, Wendy Barnwell, P42-505,
Huh?
on behalf of Mr. Adonis Sweat.
They did. I didn't know that. All right, in this matter, your name?
Adonis Sweat.
All right. In this matter, just so that there was certain parts of the proceeding that were held regarding Mr. Owens, just to update you on that and place that on the record. There was an issue regarding a letter that had been sent for the jail. The court had to rule on as to whether or not the contents of that letter were protected by attorney-client privilege. Your counsel can explain to you why the court has ruled that it was not protected by attorney-client privilege. Your counsel will also be provided a copy of the communication that was from Mr. Owens. To the extent, and the court has also ruled, to the extent there are issues regarding statements about you, that the court will rule on them in accord with Bruton, and I'll let your attorney explain that, but that was addressed while you were in back also, but your counsel was present. Okay, so that's where we were. We then got to the issue of the preliminary examination, which is set for Tuesday. There is a witness which the people wish to produce. There was argument made about an adjournment of the proceedings versus having the proceedings start on Tuesday, but it would have to go to another day to allow the people to produce that witness. You follow that so far?
Yes, sir.
Okay, so whatever doesn't make sense, I'm sure Ms. Barnwell will. But Ms. Barnwell, while you were present here, wanted to state her objections to what the court had ruled regarding the adjournment.
So Judge, I'm objecting to continuation of the preliminary examination to another date. I know you did give us February 3rd. This professional snitch, Mr. Alton Ford, injected himself into this case with no prior knowledge of anything or even knowing the people involved. And he's eavesdropping. You see him on video, eavesdropping on co-defendants Owens' conversation with somebody in the jail. So there are multiple interviews with this Mr. Ford, and Bruton versus United States does prohibit that evidence being used against my client. The unfortunate thing is the police have that, and I don't know the veracity of what was said, of what he was talking about with my client, but that's the unfortunate thing. Okay. I am objecting to a continuation of the exam because that Mr. Ford, and I had conversations with Mr. Childers, his testimony is irrelevant to us. It has nothing to do with us, nothing at all. It cannot be used against my client. So therefore, there's no need to continue on. Apart from the fact that yesterday I was in circuit court, and Mr. Childers indicated to me that there was a flash drive over in his office that I could pick up. And I did that yesterday. I've had no opportunity to look at that. But there are volumes of discovery here. I did provide my client with 924 pages. Initially, I had given him 382 pages, physical pages.
Yeah.
And so I still haven't looked at what I picked up yesterday.
And I should have mentioned that also, Stuart. There's additional evidence that was, as counsel has indicated, provided. She's not been able to review that. I don't know the impact or what impact that may have on you or Mr. Owens vis-a-vis starting exam on Tuesday. And that was another basis on which I thought it better to give a new date to begin this, let everybody look through it, figure out what you want to do with it, if anything. Okay, follow that?
Yes, sir.
All right. So,
Final takeaway here? This isn't about guilt or innocence. It's about control of the process. Discovery delays, witness issues, privilege rulings, these are the invisible battles that decide outcomes. Viewers, do you think justice is really decided at trial or right here in moments like this?
noting Mr. Stewart's counsel's objections, the court is going to adjourn the preliminary examination. I will adjourn it to February 3rd, 2026, 9 a.m. before me on that date. All right.
So I'm either gonna come on the 12th of January or the 13th. I'm here for a lot of cases. Okay,
Yes, ma'am.
all right then.
Thank you.
I texted your whoever it was that was texting me.
Yes, ma'am.
Okay, take care.
You too.
Yeah, and I know you know not to be talking.
All right.
Yeah.